welcome you all to the Law Chapter 14th International Conference of Gita International Business School. Gita International Business School was established in the year 2004. GIBS is affiliated to Guru Gobind Singh Indraprastha University, Delhi and is approved by All India Council for Technical Education, Ministry of HRD, Government of India for Technical Programs and Bar Council of India for Law Programs. GIBS is currently offering postgraduate programs, MBA and MBA International Business and undergraduate programs BBLLB, BALLB and BBA. GIBS has been graded A by National Assessment and Accreditation Council (NAAC) in second cycle. It is an ISO 9001-2008 certified institute. GIBS has been rated A+ by State Fee Regulatory Committee, a fee committee of Government of NCT of Delhi, and rated highest grading A by Joint Inspection Committee of Government of NCT of Delhi and GGSIP University. GIBS has been rated A by Academic Audit Cell of GGSIP University consecutively from past 6 years. Also, GIBS ranked as number 1 in top emerging BBA institutes in India and ranked number 2 for top emerging BBA institute in placements by Times B School Survey 2023. I extend my hearty welcome to all our guests for the International Conference on Creating Agility in Business and Technology, Innovative Legal and Managerial Strategies. In an era defined by unprecedented advancements in technology and rapidly evolving global markets, the ability to adapt and thrive has become the hallmark of successful organizations. The International Conference on Creating Agility in Business and Technology is your gateway to unlocking the secrets of dynamic worlds of business and technology, with a special focus on groundbreaking legal and managerial strategies. As we stand at the crossroads of innovation and transformation, this conference brings together leading experts, thought leaders and industry pioneers from across the globe to explore the convergence of business acumen, technological evolution and the legal and managerial frameworks that underpin success in the 21st century. Together, we will delve into the strategies that not only respond to change but also leverage it as a catalyst for growth and excellence. With a diverse array of sessions, interactive workshops and networking opportunities, this conference promises to be a stimulating technological intellectual journey where you will gain valuable insights into the cutting-edge practices, disruptive technologies and the legal and managerial insights that will shape the future of your organization. Please join us for an engaging and enlightening experience at the International Conference on Creating Agility in Business and Technology, where you will discover how to navigate the challenges of our dynamic world, harness innovation and embrace agility to achieve success. Together, we'll chart a path towards a brighter, more agile future for businesses and technology and explore the innovative legal and managerial strategies that will lead the way. Our Director, Sir, Professor Dr. Ravikant, will now address the stage.
Good morning everyone, my dear faculty colleagues, staff, participants. Welcome to day 2 for the conference. This day is mainly dedicated towards legal track and we are going to start with presentation of the law papers. In today's track we have almost 36 law papers to be presented today, which is a good number, and I hope that the presentation will bring out some fruitful outcomes during the discussion. When we talk of agility in business and technology, law has its own importance. The reason is any business or technology cannot do well till the time we have gone for having established laws and rules of how we are going to bring about that agility. The idea of this track of law in today's conference is that let's deliberate when we are talking of doing business, When we are talking of technology, many new things have to be talked of in order to bring agility. But when we are talking of those new things, there has to be some framework within which that particular new things have to be immersed in. Hence, we thought of including this law track in this conference. And I hope that today's paper presentation is going to delve some new things related to the agility as well as business and technology are concerned. So I welcome you all for this presentation session on day 2, and let the best paper win the best prize. Thank you.
The session chair of our law track is Professor Dr. Ritu Gupta. She will be joining us in a while. Next we have Professor Dr. Ravikant Gupta and Dr. B.K. Yadav. Dr. Ravikant Gupta has a teaching experience of more than 14 years. He has published more than 20 papers in national and international reputed journals and has also presented those papers in international and national conferences. 5 students have been awarded PhD under his criteria. Next we have Professor Dr. B.K. Yadav. He is working as an assistant professor in Center for Legal Studies, Associate Professor in Center for Legal Studies, Vikaragar International Business School. He pursued BA Honours, MA English and Hindi Education, LLB, LLM, MPhil, PhD Diploma in Educational Administration. He has served for 20 years as a principal of Inter College. He has written various research papers in reputed journals on topics relating to human rights. Before we begin with the law session, I would like to explain the rules associated with the presentation. All the presenters are given the time of 5 minutes to present the paper. The time given to the presenter includes the question and answers as well. The presenters are requested to adhere to the timings given. No request shall be entertained for the change of date or timings. The decision of the session chair shall be final, and in case participants have any questions, they should type in the chat box. Let's begin with the session. First we have Ms. Shivindra with us. She will be presenting her paper on alternative dispute resolution, the inevitable part of legal system. She is here with us offline.
So good morning everyone. Myself Gupta from School of Excellence and Management. So it's really nice to meet you all here. So quickly, having in mind the time constraint, I'll just start off with the presentation. So basically my paper deals with all the aspects of alternative dispute resolution, and I am going to take you back a few years, older. So when we talk about ADRs or arbitration, conciliation, these days it's a bit common for people to go for these kinds of alternative dispute resolutions. So when we track back the roots or the evolution of the entire process of ADR in India, it's already been there. It's nothing new for us to have alternative dispute resolution mechanisms. So basically we have seen a lot of panchayat systems and family elders, getting involved into the dispute resolutions. And that is the starting or the root for the modern ADR in India. So when we go back in the British era, we have the Bengal Regulation of 1772, which had provisions for having arbitration for certain disputes. So this dealt with any disputes related to accounts or any disputes relating to debts or anything commercial matter were referred to arbitration. So the legislative part of ADR starts from that is the Bengal Regulation of 1772. Later, and we had some other regulations as well, like 1793, so on and so forth. And later we had introduced sections 312 and 327 of Civil Procedure Code of 1859, which spoke about the procedures or provisions for arbitration and other alternative dispute mechanisms. Then we had our Arbitration Act of 1899, and then we had section 89 being introduced in the CPC of 1908. So this section 89 dealt only about arbitration and not the other means of ADR which are right present here in the current section 89 of CPC. So after this 1908 provision, we had the Arbitration Act of 1940. And with the evolution of this enactment, that is the Arbitration Act of 1940, the section 89 of CPC 1908 was repealed. So the section had so many committees, we had law commissions recommending for the expansion of the scope of area. So I repeat, so in the section, in the Arbitration Act of 1940, it dealt only about arbitration and not the other areas, that is conciliation, mediation, local adat, etc. So after in the 1990s, we had the recommendation of Manimat Committee and the Law Commission, which again inserted the section 89 of CPC in the Amendment Act of CPC 1999, and of course it came into effect in the year 2002. So this is a change of path. So earlier, before this insertion of the section 89, we had only arbitration, but later we had the other 4 forms of area being included in CPC section 89, which is arbitration, conciliation, judicial settlement, local adat, and finally mediation. So if we look upon these 5 modes of areas, arbitration and conciliation is governed by the Arbitration and Conciliation Act of 1996. Local adat and judicial settlement is governed by the Legal Services Authority Act. And finally, mediation, which is very new to join the enactment list. Because until recently, that's last year, we didn't have a proper mediation act. We didn't have a proper enactment which governed the process of mediation. But in the year 2023, we have a mediation act which came into effect. And all the mediation procedures, the mediators, the number of mediators, and we also have a Mediation Council of India which will govern all these processes as per the Mediation Act of 2023. So this is the evolution of the area system in India, right from the Bengal Regulation Act of 1772 till the recent enactment to join the list, which is the Mediation Act of 2023. So these provisions or these enactments provide for a two-way benefit, both for the judicial system.
Please conclude within 2 minutes.
Yes, sure. And also for the parties so that they can have an amicable settlement. Thank you.
Thank you, ma'am, for such a wonderful presentation. I'm opening the floor for any questions. Sir? Any question?
Ma'am, you have discussed about the ADR system.
Yes.
So, the faculty of management is also sitting here. Please come on the dais. Hello. So, please explain where is the procedure of ADR system given in the law and how we general people can go for ADR system of any legal litigation matter.
So people can go, see there are 2 ways to approach area. So first, you have some issue, some dispute, you go to court, you file a case, and the section 89 of CPC has given the power for the courts to refer parties to area. So see, as a layman's thought, what we do, we have a dispute, we go to court. So the court will guide people who have zero knowledge about area to they actually brief the parties about the process of area, the pros and cons of area, and they also give the other details regarding to area and they can go. That's one option. If not, when having a business deal or something like that, the parties can make an arbitration agreement, or they can have an arbitral clause which makes the parties go for arbitration when there is a dispute arising in the future. So either they can go to the court and by the direction of the court they can go for arbitration, or they may go in this way.
Thank you.
Thank you, ma'am. Next we have with us Mr. Subal Chakravarti and Ms. Smita Begum. They are presenting their paper on a national commitment on environmental pollution and reprocessing of biomedical waste with special reference to biomedical waste tools. Ms. Smita Begum, she will be presenting in the online mode.
Good morning, everyone.
Good morning.
Can I start now?
Yes, please start.
So, good morning, respected jury members and all the paper presenters present online here. So, I will present our paper titled as A National Commitment on Environmental Pollution and Reprocessing of Biomedical Waste with special reference to Biomedical Waste Rule 2016. This paper covers different areas such as introduction, meaning of environmental pollution, concept of medical waste, objective of this study, research methodology, research questions, international treaties regarding biomedical waste management, environmental protection under the Constitution of India, and judicial responding towards the biomedical waste management. So first of all, undisposal of medical waste can cause public health risk. Environmental protection needs to constant and implement an administrative and technical plan to treat and dispose of the toxic medical waste. Healthcare facilities generate many types of liquid, solid and gaseous waste in large quantities. Medical waste is considered to be a part of hazardous waste because of its negative impact on workers and in health institutions and the society and public health if not properly managed. Perhaps what makes it more difficult and complicated is the lack of sufficient awareness about the dangerous effect of medical waste, which has led to poor application of waste management systems properly, especially in the countries of the third world. Many environmental and health problems arise because of improper disposal of biomedical waste. Committed effort from all the stakeholders in health sectors are required to minimize the biomedical waste pollution. So, environmental pollution basically means the environmental degradation due to various reasons such as industrial growth, basically medical growth and population growth. Now, objective of my study is first to understand the gravity of the problem of biomedical waste and its impact on the environment. Next, objectives of my study is to discuss about the consequences of biomedical waste and environmental pollution. And this proposed research is doctoral study mainly. The research questions are: is the biomedical waste creating environmental pollution? Whether biomedical waste management rule 2016 is sufficient to prevent this problem such as environmental pollution. International treaties regarding biomedical waste management. So regarding biomedical waste management, there are three basic conventions in international area such as Basel Convention, Stockholm Convention and Minamata Convention, which was signed by 170 countries. Environmental protection under Constitution of India, Article 21, 48, 51 and G, directly and indirectly regarding environmental protection under the Constitution of India. Biomedical waste, kinds of biomedical waste. There are two kinds of biomedical waste, basically hazardous and non-hazardous. Hazardous waste includes infectious waste, pathological waste, clinical or microbiological waste, third waste.
Can you hear me?
Yes, sir.
Ma'am, your presentation was very excellent. So we would like to know how can you define medical hazards and what is the process of dispose of these types of hazards?
Medical hazards, medical waste includes medical hazards which WHO and UNICEF recognize is a not healthcare used medical UNICEF and WHO regarding as medical hazards and medical waste. So hazardous waste consists of several aspects of hospital and other biomedical waste considered dangerous to the public because of the presence of certain components with the intrinsic ability of spreading infectious, causing human health and environmental degradation.
Now that is fine. So what is the process given in Medical Council of India regarding this? We would like to know that.
Medical Medical Council, however, we studied this subject. Right now, Medical Council did not recognize the hazardous waste. It only established that it is a biomedical waste. Hazardous waste is just a kinds of biomedical waste. Biomedical hazardous waste includes biomedical waste. It is a part of biomedical waste is a part of hazardous waste. Biomedical waste management rules 2016 just declares that biomedical waste is a hazardous waste, not Medical Council, sir.
Thank you very much.
Yeah, Ms. Mehta, one more question.
Okay, sir. Okay, sir.
Can you provide examples of successful biomedical waste management practices in healthcare settings? Since you are doing research, can you share some best practices?
Yes, sir. Now I'm doing my PhD regarding biomedical waste in my town and in northeast area basically. So there is a area district name is Dibrugad, in which biomedical waste management 2016 is specifically and perfectly followed by the hospitals, dental clinics, and other laboratories, pathological laboratories, and veterinary institutions also.
Okay, thank you.
Thank you, sir.
Thank you, ma'am.
Another more questions?
Hello, am I audible?
Yes, sir.
Smita ma'am, please tell me what is the responsibility of the hospital to biomedical waste? Any
Yes,
legal
sir.
provisions related to this?
Yes, sir. Legal provisions are there, but not directly legal provisions still now. Basically, IPC section 299, 300, and 276 related to protecting the environment, and 133 section of CRPC which provides that district magistrate can handle the pollution control, which includes biomedical waste also, but not direct provisions in our constitutions and in our Indian Penal Code and CRPC and other CPC also, and evidence that there is no direct provisions, but indirectly this is indirectly related to environment, so it is indirectly concluded and included that biomedical waste is also under the environmental protection.
Okay, thank you.
Okay, sir.
Thank you, Gupta ma'am.
Thank you.
Moving on, we have Sisla Naveen Teja and Dr. Y.D. Kiran Kumar, and they will be presenting on their paper on the topic modern day risks and difficulties in the development of the intellectual property markets at the global and Indian levels. So please start with the presentation. Sweta ma'am.